Simple, first one up. What is the purpose of the Mana Whenua chapter?
The purpose of the Mana Whenua chapter, as per the National Planning Standards, is to provide information. So it's to provide context and information to assist plan users in understanding the context of the plan. The National Planning Standards mandate that it has to include things like a description of who Mana Whenua are in the district, how to contact them, preferred ways of engaging, key values, description of the region from a Mana Whenua perspective. There's a whole range of them. They're all listed in the National Planning Standards. It's a very, very prescriptive chapter. It's probably one of the most prescriptive chapters in a whole plan.
So you've used keywords like engaging, key values, and at one point you talk about the purpose of the chapter.
Yep.
Haven't you then identified something that is worthy of being an objective in the chapter from an implementation point of view? I think one of the clear messages from our discussion earlier is that this is the process chapter.
Yes.
And to me, there are some useful objectives that flow from that in terms of not only what the chapter is trying to achieve, but also what the outcomes are that you want to achieve by the processes. And it probably includes facilitating consultation. It probably includes ensuring that the values importance to the Hokanui Runanga are provided for in the plan. And I don't actually see an objective to date that sets those out. So would your advice be to us that there is merit in having in this section objectives of that type?
No, that wouldn't be my advice. My understanding of the National Planning Standards is still that it is not a place for objectives, policies and rules. My reading of the National Policy Standard is still that it's all descriptive content. If I receive advice that is contrary to that, I'll reconsider that view, but that's my view at this point.
So and I wasn't referring to rules.
Objectives, policies and rules.
In the same way that we've got the chapter on urban form and development that only has objectives in it, I'd be interested from Mr. Garbutt's point of view and also from Mr. Hill in terms of whether it's appropriate to actually use the same style in this chapter.
Yeah, I can respond to that. I'm just rereading those provisions. One moment.
Could you look at direction 26 if you're looking at the National Planning Standards?
Yeah, I was just reading that right when you said yes.
So just whilst my colleague's looking at that, just for the interest of the panel, the National Planning Standards, it's effectively a checklist of things you have to consider. So matters to consider: a history of the hapua iwi within the rohe, relationship of hapua and iwi with the rohe, environmental management perspectives and values of hapua iwi, description of resources of significance, list of relevant iwi authorities. Yep. So it's very, very, as you can see, it's really descriptive facts as opposed to positions on matters, from my understanding.
28 is just listed as matters to consider. 26 must consider the matters in 28.
Yeah.
It doesn't to me, but I'll wait to hear back from Michael.
Yes, so you're absolutely right. Page 30 of the National Planning Standards sets out in more detail the Tangata Whenua Mana Whenua content for that chapter. I think from the legal perspective, the operative part is clause 25, right at the very start. The provisions under this heading must only include context and process-related provisions. So that is in mandatory terms, context and process-related provisions. Now, whether provisions extend to include objectives, we could probably debate that. But as Courtney rightly says, it does specifically refer back to para 28, which is quite a long list of matters that must be included. And none of those talk about objectives, policies, rules, methods, or anything of that nature. So my advice to the panel and to Courtney is what the staff have done is following in the prescriptive formula what the standard provides for. They haven't omitted to put anything in there that is required. That section doesn't require objectives. Whether objectives could be added in addition because they're a related provision might be debatable, and I don't have a strong view to say that they're absolutely ruled out. What I can say is objectives or policies aren't prescribed as being required. The default is they probably shouldn't be in there because it must only include, so it says that these are the only things that come in there. Context and process related provisions, it's probably drafted that they're all listed because they've got quite a long list. And the fact that there's no objectives in there suggests to me that they're not anticipated.
I think the other thing to add, if you look at 26, it says these decisions must be made after engaging with tangata whenua, mana whenua, and that was part of the process in drafting that chapter, which doesn't contain objectives and policies.
Yeah, thank you. That is an important factor because this is setting out the provisions advised by mana whenua as important to address the matters in 28. So that's my fulsome answer. Sorry, it's a bit
Okay, sorry.
stream of consciousness.
Yeah, to add to that, I think it's also important to look at the matters that need to be covered in this chapter, which is in that list in paragraph 28. And from my technical planning perspective, I struggle to see how objectives would align with these. For example, how...
Can I take you back to paragraph 25, to
Sure.
the second sentence in paragraph 25 that said other tangata whenua, mana whenua provisions must be integrated throughout the policy statement or plan. So in that context, that gives authority to have objectives, policies and rules throughout the plan. So I interpret provisions in the wider context arising from that part. It must interpret the same way as the word provisions in the first sentence. And reason for asking is that we've got a number of submissions that are opposed to this chapter and the approach, and picking up on your comments earlier that a lot of the submissions in your view are raised as a concern to other parts of the plan rather than to this part. But how can we provide a sensible, from the point of view of the wider public, provisions in this chapter that actually clearly articulate what it's trying to achieve? And I guess one technique that comes to mind is actually focusing it by way of having some objectives in this chapter. So it's something that I'd like to give an opportunity for the parties and council advisors to think about a little bit further, please. Just in terms of what's the outcome that we're trying to achieve from the submissions that we've got in front of us that actually provides clarity moving forward, as well as clarity through the processes that will be adopted later, in particular consents.
Can I just say, it's probably worth noting that the SASM chapter does include objectives around the process for engagement and the values, etc. So perhaps this is better picked up in that once we're discussing those provisions through that hearing process.
Which I guess from a process point of view from the panel, there's a number of matters that we've talked about today that we're hoping will be picked up as part of the report when it does come to the sites and areas of significance.
Absolutely.
And if it's helpful, although it'd be a difficult task, if it's helpful, we could probably issue a minute to provide these things we expect to be dealt with in the further reports.
So one thing, when you are thinking about answers to what's being put on the table. It might be worth looking at the Otago RPS, which is quite a recent document and is just over the border, so just food for thought.
Yeah. Something I'd just like to stress again, I mentioned it earlier, I think it's worth reiterating, is this approach to SESM is only relevant to this chapter in 2 sentences in the whole chapter, and it's been used as an example. So in theory, I'm not recommending we do this, but in theory, if we removed that sentence and put in a different example of how mana whenua values had been integrated into the plan preparation, we wouldn't be having any of these conversations. That is the only reason that this conversation is part of this chapter, is because the chapter says a specific example of the approach this plan has taken to acknowledge the relationship Ngāi Tahu hold in the natural environment is the SESM chapter. If we had picked a different example, then none of these submission points would relate to this chapter. So just to be able to differentiate those 2 matters around SESM aren't central to this chapter and its content. It's just this one line as an example is the only reason that these are tagged, and I think that context is quite important for us to recognise.
Help me to understand what you've just said.
Yep.
Are you saying that the mana whenua chapter has been identified in other chapters, and that's created a response that should have actually went to the chapter of general rural or instead of the mana whenua chapter?
My reading of the submission points is that there is a large number of them that would be the case. In my Section 42A report, there are a number of matters that come up that absolutely relate to the mana whenua chapter, specifically around discussions around the definition of mahinga kai, absolutely. Around some of the wording around primary production, absolutely, that relates to this chapter. Most of the matters, because I'm also looking after the SASM Section 42A report as well, so I'm reading both. A lot of the submission points that relate to the mana whenua chapter are duplicates of ones that relate to the SASM chapter that have just been tagged to this chapter as well, because of that 2 lines in Section 2.4 that use the SASM approach as an example.
At paragraph 117 of your report, page 27, you refer to the 91 activities identified by Southland Federated Farmers.
Yes.
Was that in their submission?
Yes.
Okay, so we need to go back to the original submission if we want to see what they are.
Yes, there's an appendix in their submission that lists them. As you will see in both my Section 42A report and the evidence of Ms. Barron, those 91 activities, none of them are restricting an activity based on Ngāi Tahu cultural values solely. The majority of them, I think it was something upwards of 70% of them, are actually permitted activities, that only if you breach the permitted activity conditions flip you into being restricted, discretionary, or needing a consent. And the matters that you need to consider as part of that consent, there are none of those examples where Ngāi Tahu cultural values are the only thing to be considered. It is usually one of between 4 to 6 things that need to be considered. So I would look at that 91 activities within that context.
I have just realised that there was one question that I did want to ask you when I went
Fantastic.
through and weeded. There was one at the top of the list that I do need to ask, and it relates to what you just said there, talking about, you used the phrase Ngāi Tahu cultural values.
Yes.
So where a choice has been made to refer to cultural values without reference to Ngāi Tahu, does the word cultural mean more than just, like, cultural is a broader term perhaps? Would you agree with that?
My professional view is that the term cultural values is broader than just Ngāi Tahu cultural values. That is why my preference in most cases has been, when discussing Ngāi Tahu cultural values specifically, to call it that. When talking about cultural values, that's wider again. So cultural values can include things such as the cultural values of the rural community, the cultural values of trout fishers, the cultural values of rugby players. These are all cultural values. That is my understanding of it, and that's why when drafting it, we put Ngāi Tahu cultural values specifically, when that's what we were referring to. I'm aware that some changes may have altered that, and that's something to be discussed on a case-by-case basis.
Okay, something to be looking out for then. And
Yes.
the other thing I was wondering was why the string Ngāi Tahu cultural values as opposed to Ngāi Tahu values?
Without speaking on behalf of Ngāi Tahu who hold these values, my understanding would be that not all Ngāi Tahu values are cultural values. Just like not all values of any community are just one thing.
Yeah, so sometimes we want to be specific about Ngāi Tahu values more broadly, and sometimes we want to be referring to Ngāi Tahu cultural values, but we have to be careful when we're using either.
I would agree with that, yes.
And there was a follow-up question. This is actually this is a bigger one.
Nice.
And it's probably one for Hokonui, but I'm going to give you a chance to respond if you want to. Those headings in MW 2.3, which at the moment are being described as values and referred to by the different provisions, are all the headings in MW 2.3 values, or are some of them something else? I guess I'm wondering about a paradigm or a Te Ao Tahu view, or I'm wondering if values is the right term, and it's okay if it is. It's just a question I wanted to ask.
That is a good question. I agree with you that it's not something that I can fully discuss, but I can provide background on how the chapter was drafted in relation to that. So in the National Planning Standards, one of the things you have to discuss is environmental management perspectives and values of hapu or iwi. And that is the bullet point that section is responding to. So when drafting it, the initial drafting, we took that wording across. The use of the term cultural values together, more than anything else, was likely out of habit. It's not something that was, well, Hokonui Runanga drafted this chapter. As part of that process, it can be assumed that the appropriate people with tikanga background approved certain sections of it. If that's the case, then that's the wording. I have a strong suspicion that that term may have just been used out of habit, though. But I note the point that cultural values and values aren't synonyms at all times.
I note that the first sentence of 2.3, or the second sentence, says some of the values are listed below.
Correct.
Which ones are missing?
I don't think that it would be reasonable to be able to create an exhaustive list of a culture's values. And if you did, you would be looking at a PhD dissertation. If you wanted to include something of that level in a district plan, you would be, just this one chapter could be up to 60,000 words long. If that's something that the council was interested in, that's a different conversation. There's also discussions around what information is culturally appropriate to share in this form and what is not. And that's something that's not the place of a planner to discuss. But I go back to the point that I think it would be very inappropriate to try and discuss the whole values of a culture in a district plan when that is PhD level dissertation work.
So where in the National Planning Standards does it actually say that the values are required to be in the plan?
28A3.
When I look at E, it talks about an explanation of how values have been considered.
So
It doesn't say list the values.
yes, because it says that in 28A3.
Okay, so recognition of environmental management perspective. So recognising, does that mean you list them?
Yes.
All right, so if we go to G, which doesn't show up there, it shows up in your report on page 33. Yeah,
What
sorry, 1G it is.
One, in what document are you referring to?
In Appendix A.
Of what document? The National Planning Standards,
No,
the
of
supplementary evidence,
your
or the section
Appendix
42A?
A to your evidence.
Okay, and whereabouts are you?
In G.
In G.
So bottom of page 33 of
Page 33. Cool, thank you.
I guess the first thing is that there's a sentence that says the chapter's been prepared in accordance with
Yes.
the National Planning Standards.
Yes.
So from we don't have any other chapter that says and then list everything that's in the
Yes, correct.
requirements. So the page that follows we don't actually need.
Potentially, yes. The reason that that section was put in there was to front foot questions from the community about why so much detail around mana whenua was put into
Yep.
the plan.
Yep.
We anticipated some questions about why this information was in a district plan when it doesn't have objectives, policies and rules, because for the average plan reader that would seem out of place. So we wanted to make it very clear to plan readers why that information was in the plan.
I thank you for that. That's the response I was expecting. In G, it talks about a list of the statutory acknowledgements,
Yes.
and I see in what follows the statutory acknowledgements are referred to, but I didn't see a description of how they affect the policy or plan or are reflected in the plan provisions.
It is in there. I have, off the top of my head, we combined that into a different section just so that the plan wasn't stupidly long. So that the plan was more concise. I can't find it off the top of my head.
Okay, so just make
it
a
is in
note
there.
and we'll come back
Yeah.
to it. So you've highlighted that the Runanga drafted the chapter, and to me that actually gives rise to a style inconsistency with the rest of the document, because a person picking up the plan wouldn't appreciate that. So when I look through a number of the provisions and I'm looking at the paragraph immediately before section 2.3, in the third line it talks about our sense of connection, our long-standing
the first
night out.
person nature of it.
Yes.
Yes.
Yes. So from that point of view, I think some rewording is required so it actually reflects the Hokanui Runanga values, but is written in a style where it is coming from the council. And it becomes more of a concern later under Maury, and I'd number it 2.3.3. So I think it's important that we have a consistent numbering through. In the middle of that, it talks about the overuse, depletion or destruction of natural resources leads to a diminishment of Maury. This is unacceptable to us. So there is a style thing there that it's unacceptable to the Hokanui Runanga. So that type of rewording is needed through the chapter. So it actually is a reflection of the council's view, not of the taking into account the Hokanui view. Do you see that as appropriate?
I understand where you're coming from, and I absolutely understand that. I think that the broader question that would help decide whether or not that's appropriate is to consider whether or not this is a co-drafted plan or not. And that's not a decision as a plan to make, that's between yourself and, well, between the council and the Runanga. If it is decided that there is only one voice that needs to go through this whole chapter and that it's inappropriate to have someone else's voice in a chapter talking about that group's own values, then that is a change that can be made, but that's a very deliberate decision that the panel needs to make based on discussions with those co-drafters. That would be my recommendation back to the panel.
In Te Reo Maori, the very last sentence seems to have something missing. It reads,
Whereabouts, can you please give me a reference?
Yeah, on page 37 of your report,
Yes.
under Te Reo, the last sentence, again using Mahinga Kai as an example, when valued species disappears from a local ecosystem or activities.
The heading on page 37 is Whenua Land.
No, I'm looking at in your Appendix A to your evidence, initial section 42A report.
Yep, that's also where I'm looking.
So under the heading of Te Reo Maori,
Oh, yes.
last sentence,
Again, using Mahinga Kai as an example, when a valued species is in a local ecosystem or activities. Yes. Yep, that would be true. That does look like there's something missing.
I referred earlier to the sites that appear in the heritage section, of which there's 3. If the intent is not to have sites of significance shown in the plan, should some or all of those be deleted?
Those sites are archaeological sites, and that it's different to a site of cultural significance.
They're not under the archaeological heading, they are under the heritage heading. Archaeological sites are shown separately.
That's not my chapter, so I can't comment on that.
Yeah, sorry, HH74, the other 2, you're right, are HHA in front of them, but at least one of them are Tutorial Reserve, so should that be shown? I guess it's something, get some feedback from the Runanga. Is the council, and I guess it's a wider one maybe from Mr Hill, intending that this be an E-plan at the end of the day? Sorry, Matt, are we heading to an E-plan? Are we heading to an electronic plan in terms of what's in the government, in the standards?
Ultimately, yes, there is. I don't know off the top of my head what the time frame is, but there are time frames in the National Planning Standards within which all councils need to have an E-plan. I think when we started this process, the expectation was that that would be done at a regional level, so all the councils would attempt to do that together and use one provider. Yeah, I'm not sure where discussions have landed with that. There was, at the time, there was national direction that we had to have one plan for the whole region. That's now not the case, I think. And so we probably need to have further discussions with the other councils on that.
I've just... about the E-plans. Local authorities must comply with the mandatory direction of electronic accessibility and functionality by 1 year from when the planning standards come into effect.
Does that give rise to, and it's beyond just this chapter, and it only popped up when I was reading this, does that give rise to some considerations in terms of the way that we do our decisions and also the content of the plan?
I think the main change from other e-plans that I've seen is that cross-referencing between parts of the plan is easier because
so
you can
much
create links and that sort of thing. But I don't think that necessarily needs to delay your decision-making process. I think that could be considered after you've released your decisions, because then we will have the updated version of the plan. So that would be the logical step to then transfer that into an e-plan framework.
E-plans don't, from my experience, and I'm interested in my colleagues as well, from my experience, e-plans are not text-wise any different to non-e-plans. It doesn't change the way you write the plan. It's literally just the way it's uploaded onto the internet. So you don't write policies differently or objectives differently to enable it to be an e-plan. Doesn't change anything like that from my experience.
I can add to that slightly as well. Given that we have followed the national planning standards, they're all sort of the way that we use the abbreviations and the titles of everything, that can easily translate then into an e-plan, and even down to the sort of table format that we've got here with the kind of permitted activities with the clauses, and then if these aren't met in the right-hand column, this is the activity status. That actually kind of mirrors what an e-plan looks like or can look like. I am aware of plans that have transitioned to an e-plan based on sort of a Generation 1 operative district plan, and there's difficulty there because obviously they're written very, very differently in terms of, I guess, an anticipated e-plan, but it should be a reasonably simple transition to make this an e-plan, and it wouldn't, in my opinion, change how the plan works or any of that type of, I guess, functional aspect of the plan.
That's the intent of the National Planning Standards, from my understanding, was to make sure things like that don't become issues.
Right, it's the links between this and particularly the sites of areas of significance that I was thinking through. When the resource consent's prepared, one of the provisions that must be looked at are the objectives and policies of the plan. So why is it necessary to refer to objectives and policies as part of your recommendations for the assessment matters?
So originally they weren't. Most of that is... Also, I'm very aware that we're moving into topics that actually relate to the SASM chapter and don't relate to the Mana Whenua chapter at all. But if the chair is happy to allow us to blur like that. Originally they didn't. So that wording that flicks it back to the objectives and policies. As you're saying, that's naturally what you do anyway. But some of the amendments that Hokonui Runanga have requested that I've agreed would be an appropriate change to make. In those objectives and policies, it's creating specificity for what kinds of Ngāi Tahu cultural values should be in scope within that chapter. So that's why it specifically refers back to the objectives and policies. I believe that's the intent. I think that's something that Ms. Berrin can probably discuss more in her evidence, but that's my understanding of it.
And again, when I make reference, it's on your
Yep.
Appendix A to your
Cool.
Section 41A report. Section 3, Mana Whenua, starts off with the Gore District Council is entering into a revised Tawiti-based relationship. What is a plan issue? You know, what's the relevance? You make reference to the Charter of Understanding. I just don't see why that issue is relevant for inclusion in the planning document. I guess other than what you said earlier, that it's just trying to give a little bit of context to people, but it's something that could happen or may not happen
It's already happened.
in terms of...
The relationship at the signing of, and this is probably something that Mr. Nichols can speak more to, but it's something that is reflected in the signing of the Charter of Understanding.
Right, so that sentence then, I guess the wording that's used implies for me that there's something new beyond the Charter of Understanding. So I guess Terry can talk to that later. You've added in your appendix provisions throughout other sections of the plan, and there's one that jumps out there that probably Mr. Hill can respond to, and it's on your page 45 in relation to Noise Rule 4. And Noise Rule 4 is reflected there as a permitted activity subject to a standard, and non-compliance with that standard is a controlled activity. But when I go and look at the standards themselves, non-compliance with the standard is a restricted discretionary activity. So the column that's in the rules, should the status of that be the same as the status in the standard provisions that follow later?
Sorry, I haven't got that in front of me, but that's something we can consider in the noise hearing.
Well, it comes up in a number of chapters. It's what's the status of non-compliance in the rules versus the status, and in this case the rule refers to the standard. It says if you don't comply with the standard, it's restricted discretionary. You go to the standard and it says the status,
controlled in the rule, restricted in the standard.
Yes.
Yeah.
So there's an inconsistency.
Yeah.
And it appears in a number of the rules and the plan. So this is the first time that it's jumped out at me.
I'll need to have a look and clarify that.
Now, one last thing, and just from a style in terms of writing a decision, I prefer to use first names in the decision, but there will be cases where it's appropriate to give you some other sort of title. Miss, Mrs, Ms, whatever. What is preferred, please?
MS, Miss. Thank you. I appreciate you asking.
So that's all I have at this stage. There will be others. Thank you.
Thank you. Any more comments, Courtney?
No, just thank you for your questions. I appreciate the effort that you've put into considering the chapter.
And, we'll pass over to your legal support for some further comment, or...
Would you like me to comment now, or just I was proposing to just respond in the context of our presentation, if that's okay with the panel. I'll just wait while the AV gets sorted. Great, thank you, panel. My name's Josh Leckie. I've appeared in front of you before, earlier in these proceedings, and grateful for the opportunity to come in person this time. Just to orientate the documents, hopefully you've got my legal submissions, which were filed last week, and also the memorandum which my friend Mr. Garbett spoke to earlier with the fraudulent slip, it would seem on my part, given the tone of some of the questions today, policy for the SASM chapter relating to this future work stream, and I'll speak to that shortly. And I've got a team of experts and cultural witnesses today. Some are on the screen and some are here with me, but just to broadly introduce those first, Terry Nicholas, who the panel are aware of is here live and will speak to his evidence. Is Joe Brand, I see on the screen there as well, has provided evidence. Elsa Kane, also on the screen, provided evidence in relation to Apiti Hono, Tatiti Hono. And then planning evidence, now there's two briefs. Dr. Murchison provided planning evidence on stream 2. Potentially won't be a focus of your questions, but is available if needed. And then Ms. Beran to my left, being the stream 3 evidence. It's been useful to be here this morning, and that I don't think I need to repeat, unless the panel wants me to, aspects that I think are understood in terms of matters on the table for the panel today. So in that sense, some of my legal submissions are more for background and for your decision making. But just for completeness, I appear today for Hokonui Runanga in relation to hearing stream 3. I've introduced the witnesses for the Runanga today, and at paragraph 3 I also just introduce Ms. Beran's Appendix A, which are the amendments to those provisions which were informally conferenced with Courtney. But fundamentally, the relief sought by Hokonui Runanga is necessary to provide for the Apiti Hono, Tati Hono information and data outcomes, and these remain incomplete but underway, and to provide for those within the regulatory tools available to the PDP context. So I think that's quite important from the outset, that the Apiti Hono, Tati Hono approach is an information gathering process. It's not an RMA regulatory response in its own right. They're two quite different things, and Ms. Kane is the best person to speak to that, but I've just introduced that to hopefully trigger that discussion further in the day. And in our submission, the relief sought will most appropriately ensure the PDP gives effect to Part 2. Rightly or not, Gore is the first local authority in New Zealand to provide for that, and I've said there, while this does present some first cab off the rank challenges, in my submission these aren't insurmountable and can result in a district planning framework that is nationally leading in its approach to recognising and providing for the relationship of mana whenua with their takiwā. I've introduced the Runanga. I won't read out the next section. I think that's well understood. If I could just turn to paragraph 19, which are the key issues as I see them for the Runanga. They are the appropriate ways to recognise and provide for the relationship of Ngāi Tahu and their culture and traditions with their ancestral lands, water sites, waihi tapu and other tonga, so the section 6E lens. And I'll make a comment about 6F shortly. The Apiti Hono, Tati Hono approach, which Ms. Kane will be able to help us through what it is, how it relates to the PDP, and I'd add to that how it doesn't, so the differences, and how the panel should discharge your obligations in relation to that. And then the recommended changes to the PDP, and I'll leave Ms. Beran to speak mostly to those in that they resulted from that conferencing. Over the page, at page 4, I've introduced the statutory context. Again, it's well known to the panel, and in my submission, the Runanga relief has a strong founding in that statutory context. 6E, I was obviously here earlier and heard the exchange with the Commissioner on 6E and 6F. 6E is a focus for the Runanga, and I know Ms. Beran's evidence has expanded on that. I agree with my friend that, or my interpretation of the answer, that there is an overlap and that there'll be 6E matters that are relevant to the cultural elements of historic heritage. It's probably a moot point whether they fall in E or F and that they have equal standing in the RMA. But 6E is certainly the focus for the Runanga, and that's Ms. Beran has provided planning evidence on that. But that's not to say there aren't 6F matters at hand here. There certainly are, but there is overlap. And E and F, and indeed all of the matters of national importance, they're not exclusive lists in that you can fall into more than one category. And in a legal sense, that they'd be given equal weight anyway.
So understand that point. Does it have a bearing though on plan structure? For instance, because we're following the national planning standards and there's some differentiation specific to historic heritage and then sites and areas of significance to Māori, if we find that the box that we're trying to squeeze into doesn't work, is that because the structure that we're following in the national planning standards is thinking about section 6F when we want to be thinking about section 6E?
Potentially. I mean, the national planning standards, I think it's quite important that they do talk about areas, not just sites. So in that sense that they do allow that broader consideration in relation to the historic heritage aspect. I mean, what I was going to respond when I introduced the additional policy is that from my perspective, what's important is that these matters are all put into the plan. I don't think it's particularly material where they sit, as long as they fall into the plan. Now, I know that's a very purist approach, and it's easy for a submitter to turn up and say, but that's fundamentally why I still think it's important to talk to the SASM new policy, for example, and that it's all critical as to how the plan overall works. I appreciate that the panel do have the planning standards, but I don't think that they provide a barrier to the relief that's being sought by Hokonui here. The remainder of my statutory consideration section, I've summarised the Te Tiriti principles, which are very important to the Hokonui submission. But perhaps if I could just talk to paragraph 31, which is my submissions to you as to how you apply those hopefully in a practical sense, and that's recognising the relationship, having particular regard to kaitiakitanga and the ethic of stewardship, section 7 matter, providing for that relationship, and then fulfilling the requirements of section 8, taking into account the principles of Te Tiriti, which I've summarised earlier in those submissions. But if I could just turn the page now and really talk to the key issues for Hokonui, which is to appropriately recognise and provide for that relationship with the lands. And Ms Beerin's appendix, which I'll let Ms Beirin speak to, has addressed paragraph 36 of my submissions, which are and it's been come up this morning in the hearing as well, the looping in of these objectives and policies and the Mana Whenua 2.3 into the provisions of the plan. And I'll let Ms Beirin speak to that. But then the other key matter that I'd just like to introduce now to set the context is in relation to this additional workstream policy, which I've provided the memorandum on Friday. And I'm not reading from my submissions now, so I'm just speaking to the policy. But fundamentally here, we submit that there is currently a gap in the plan, and the policy is an attempt, a pragmatic way to fill that gap, and that's why it's important from Hokonui's perspective that this does fall into the plan as a provision of the plan, as a policy of the plan, and that adding it to the plan will help complete that loop and enable you as a panel to issue your recommendations back to the council. I have turned my mind to whether it could be a method that's set outside the plan, but the challenge for Hokonui with that is it leaves a gap within your current recommendations that would then go to council, and the only way I'd see that gap being filled would be to enable that to then come back to this forum, which could just cause quite significant delay in terms of your role in making the recommendations to the panel. So the only way I can really see this gap in the plan being filled is through this future workstream policy, it enables the commissioners to make their recommendations to the council and for a process to be gone through which introduces section 32 and then gives the council their opportunity to do their job. I can see Mr. Hovell's lights come on, so I'll pause.
Yeah, thank you for that, and the way you're handling the submissions is greatly appreciated. Good style. For us to consider the new policy, do we need to have a section 32AA put in front of us to consider?
Yes, you do, and you have one. So Ms. Behrens considered the policy as it stood, to be fair, before Mr. Garbutt's legal submissions were filed. So what I'd suggest, without leading questions to Ms. Behrens through this process, is for Ms. Behrens to speak to the changes and in particular any change to her 32AA. Because you do need that, and I've briefly touched on that in my legal submissions, but they were prepared before the policy was amended. So, so yes, you will need that, and you'll also need to reference, if you're minded to accept my submission, reference that within your decision as well. So the policy is a somewhat pragmatic response to address this gap. And listening this morning, whilst we can't know for sure what the 32 recommendation or evaluation report will determine, and therefore what may or may not fall into a plan change, but conceptually it may address some of the interrelationship points that have come up this morning between these different chapters and the way that the relief for Hokonui is best provided for within the plan. But we need that separate process to be gone through to really test that, and we can't do that within the scope. Yeah, sure. And
Actually, before you proceed, I was just waiting to see if
sorry.
my fellow commissioner had a further question. You were just saying that some of those decisions and interrelationships that we're grappling with in this process might be further built on through a process that is envisaged by this new policy. Would you agree, though, that we've got a responsibility in this process to do as much as we can with the information that we have available to address what we can already see? And that particularly because we really don't know what time frame or whether this policy will unfold or when within the life of the plan. Do you see that as an issue for us?
Yes, it's certainly an issue in the sense that I agree with you that you have a role in this process to find the most appropriate provisions that give effect to Part 2 of the Act within the, in reliance on evidence before you, but also within the scope of the process. So I certainly am not submitting that you should rely on this policy to do that job in its entirety, because that's certainly not the case of the Runanga. The Runanga's position is that this policy is part of that picture, but I agree with you that both mainly due to that timing point, and that these provisions are all going to plan, likely to be operative and be in place before this future process is gone through. So that they're the provisions that will be determined by the panel. So I, in a long-winded way, I agree with your statement that you do have that obligation. I thought it might be useful, and I've started this at 44 of my submissions, to give some context to other scenarios that this outcome's been put into district plans. And there's no particular magic to the examples other than the processes that I've been involved in myself, so I'm aware of. One was, and it's an interesting one given Councillor Hovell's questions earlier about the first generation Queenstown District Plan, because it sounds like it had a similar challenge as the second generation plan. So the Upper Clutha case is a Judge Hassan decision around the almost operative now Queenstown District Plan, so an Environment Court decision where through the court process the court identified a gap, and it was in so not a cultural context, it was a gap within the landscape schedules. The lack of schedules. The fact that a huge amount of the Queenstown district is zoned rural and is an outstanding natural landscape, and in the court's eyes there was a lack of guidance around what were the particular values that the plan was seeking to protect and what were the threats on those values. The court in that case didn't have scope to address that or fill that gap or address that concern through the process, and that's what resulted in this, or my read of this policy at 45, from the court directing the council to go through plan changes to implement policies that they'd put in place. And in effect, those plan changes were to introduce what have become known as landscape character units into the district plan, so quite broad landscape overlays that describe values and describe threats to those values that can be used as a tool through resource consenting. So completely different context, with, but an example of where the court has put in place a future plan change. Different scenario here, and I acknowledge my friend's legal submissions on the constraints that the panel has in terms of an inability to direct to the council what they can and can't do. But, so that was just one example. The second an example I was acting for Ngāi Tahu in the Marlborough Environment Plan, where we, as a group of parties to mediation in the Environment Court, needed to grapple with a way to best give effect to the MPS 2020 in a context of with a plan that had been notified prior to that document being brought into play. Very difficult and quite lengthy process to work through, but fundamentally where we got to and was signed off by the Environment Court was giving effect as best the council could to the MPS 2020, but with a requirement for a future plan change process. I acknowledge that situation was more clear cut in that there was a clear MPS directive, but again another example of a district plan, or it's a one plan in that case, acknowledging a gap and the need to fill that gap with a future process. So I've just provided those two examples for some context. So that what in effect that this future process will allow for, and Ms. Behrens discussed it in her evidence, is for the Apatihono Tatihono process, which again is, I potentially overly summarise it as a knowledge and data type process, a gathering of information process, for that to be completed to then feed into the future plan change, because that's the gap that we around this room, I suspect, are grappling with at the moment, is we don't know the outcome of that process and we don't know how that will feed into the district plan. 47, 48 of my legal subs are potentially, well, they are a moot point now, in that Hokanui are comfortable with the redrafted provisions to respond to Mr. Garbutt's legal concerns with the earlier drafting.
Can I, just thinking about your paragraph 46,
yep.
It seems to me that what you're describing is an iterative process, an evolution of a planning instrument over time, but also from the evidence suite that we've got from Hokanui, it's actually envisaged that that knowledge and data resulting from Apatihono Tatihono is also likely to evolve, improve over time, and also be iterative in nature. So does this lead us back to thinking about at any given point in the life of this planning instrument, there might be improved knowledge or data, which may or may not be specific to these matters, and that as knowledge and data improves, you know, plan changes can occur down the track and over, you know, quite long timescales. So in that respect, is this about, again, best available information at each point of this plan's life?
In a way, yes, because that I agree with your sentiment, Commissioner, that that process is evolving and is probably always going to evolve. And I can't speak to the end outcome of the process, but from my legal perspective, I suspect it'll never. That process will always be evolving, and the loop back or the way that will need to be addressed, I suspect indefinitely, is through that engagement with Hokanui, and that the plan will, I suspect, to Hokanui's perspective, never entirely capture all of these outcomes. There'll always be a need for engagement on a case-by-case basis as certain resource consents are made in the district moving forward. So in that sense, I agree that the knowledge and the process will always evolve, but at this moment in time we're in right now, the concern of the Runanga is that the plan doesn't achieve the purpose of the Act with the knowledge we have available now. So that's the attempt to address that gap right now. It may be that the intent and the effect of this new SASM policy actually is applied in future plan changes or another generation of the district plan as that information and knowledge grows. But for now, we're attempting to capture this moment in time for the life of this district plan.
So what you just said there was that at the moment the plan does not achieve the purpose of the Act. Of course, we have to achieve the purpose of the Act in making our decisions. And I'm just conscious of the exchanges previously with Ms Bennett around the way the co-drafting process and interaction with Hokanui informed activities of concern and responses to those. Is it perhaps more accurate to say that the knowledge we have at the moment has its limitations and can be improved upon to better achieve the purpose of the Act? Is that a more accurate?
Yes, I think that is a more accurate description. All I'd add to that, though, is I think part of the relief being recommended by Ms Barron as well, I think it's important that it's understood what the plan is or isn't, or can or can't achieve through the current mechanisms as well, and that but yeah, I agree with that summary, that it can be done better is probably the take home. And an example on that importance of plan users and everyone understanding what the plan is or isn't trying to do is this concern that just because there are no listed scheduled sites of significance doesn't mean there aren't areas or sites of significance to Hokanui Runanga within the district. That's an example of that tension being played out there.
And at the moment, in the absence of that additional information coming through, we are reliant on process elements and activity settings and the provisions that we have
to
work
right.
with. Yep.
So those tools that sit within at a rule level, those triggers, both what they're triggering, so what's a permitted activity and what's not, and then whether the matters of discretion or matters of control are referencing those Ngāi Tahu cultural values. They're the tools that this plan is using, and the relief from Ms. Beran is recommending are the way to achieve that.
I'll just flag that I do have some questions about the revised policy, but I'll wait until we hear the planning evidence, but we'll relate to that.
Yes.
And I guess coming back to the point I raised before about what does a provision mean, provisions is defined in section 32 of the Act, which, because it's in section 32 and applies to what's included in the district plan, that may have some bearing on the way that we interpret it as well.
No, I appreciate the signal, and that reminds me, happy to take questions or exchanges throughout the sort of presentation, because a lot of this, I think the evidence will assist it as well as we work through it. Or the evidence may open up more questions, which is fine too. I can move through the next couple of pages, and that I've really spoken ahead to that around this future variation. Just to Councillor Hovell's point, 56, Ms. Beran has undertaken a 32AA that can be refreshed through questions at this process. Ms. Kahn's the best and most qualified expert, certainly on our team, to address Apate Hono Tati Hono. So I've summarised that in the page 11 and page 12, other than to just reinforce that in my submission, my take of the approach is it's an information gathering tool. It's not a planning mechanism in its own right. And I think that's an important distinction for the panel as you work through this. At the moment, in the present time, the PDP does not fully give effect to the approach, but it's not a criticism of council, and that because it does sit outside the PDP. So obtaining the information and cultural context that will flow from that into the planning regime is really the question we're grappling with through this hearing and the SESM hearing as well.
I have, excuse me, I need some clarity with this.
Yeah.
So what you seem to be saying is it's not a planning tool as such, but background information and more information in regard to Ngāi Tahu regionally, including obviously the local Runo. So how does that produce a gap for the the working and consenting that emanates out of the plan?
So in the current context, in the current context of the Gore plan, the gap for Hokonui is that because this process isn't complete yet. I'll give an example if I may, because I found it quite useful, and it's why we attached it to Ms. Beran's evidence. But the report that was Appendix B, and I think it came up in questioning earlier, the Apate Hono Tati Hono assessment report. Again, there's others on the team who can speak to this. But to me, that's when I reviewed this, it was a really good, tangible example of an output of the process, which is really useful, but at this stage hasn't been incorporated into the plan. So the approach hasn't been completed, so therefore the outcomes of that haven't been able to be incorporated into the PDP. So that's the gap that I'm talking about. I'm not saying that the outcomes of this report are what should go into the PDP. That's not for me to say, but I found this a really useful, tangible report which has applied the approach and given some really, I think, quite clear outputs that could be relevant to that future variation. But from a pure legal perspective, and I don't have instructions on whether this is what Hokonui would want in the plan, but I don't think you'd have scope anyway, for example, to pick up this report in its entirety and feed that into the plan, even if that was the outcome right now that all the parties to the table wanted, because that's not the context that the plan's been prepared in and people have submitted on.
If we, for instance, are guided by the assessments that have already been done, and through our dialogue with Hokanui, identify that there are submission points that allow us to pick up elements of those recommendations and carry them through into the provisions. Is that a pathway for us?
Yes, absolutely, and that's the pathway we went through with the Christchurch replacement plan, which again, different context, different runanga, but I raise it as an example where Ngāi Tahu worked with council to post notification of the plan, provide objectives, policies and rules to essentially backfill, if you like, some mechanisms to protect cultural values. So, but the proviso there was it needed to be done within the scope that was available, and that was a process that Ngāi Tahu worked with council experts on, and that's resulted in the current provisions that sit within the Christchurch replacement plan.
So I guess following up on Councillor Bolger's question, and it will come back to the policy later, the assessments will be done then, and there'll be some recommendations in it as to outcomes that the runanga would like to achieve. But then there's an exercise to go through in terms of what is the process that should be followed to arrive at that outcome. And some of them will not fit within the district plan framework. And even if there is a land use component, the Section 32 assessment that is to be done later will determine whether it's an appropriate method to be included. That Section 32 report is a, dare I say, just part of the process, not the total process. So the issue I've got with the policy is that I think it's limiting. And I think something that actually acknowledges that the Section 32 is really the end point of, once it's worked out, how the values are given effect to. And in some cases it may be design guidelines that sit outside the plan. In other cases it may be consultation processes. But some of those will sit outside of or be dealt with prior to even looking at Section 32. So I guess what I'm flagging in terms of the policy, I see it as actually being a bit narrow in the way that it's given a particular outcome when there are likely to be a range of outcomes that need to be adopted.
And that's a helpful steer, and I'll think about that. I'm sure my friend will too. Just on around, I take your point that I've written it in a way that assumed the outcome sat within the district, the ultimate outcome sat within the district plan.
Just to muddy the waters even further. Now, I'll assume that the council will continue to develop its relationship with the runanga, and that will be productive and work very well. But I'm assuming this approach is a regional approach, so how can we incorporate a variation with a policy or an approach that may be considered by other councils, authorities, and it may take a very long time before that gets to a completion. So I'll pick up on Commissioner Hovell's point. Can this actually sit outside the plan, like an iwi planning document, or? And I know you probably can't give me a definitive answer, but that's a potential. And would that be in some measure achieve the expected purpose?
And this is just my legal response. I don't have instructions to that point. But the challenge with that is that the outcome of this process to Hokanui is the district plan, and the tools within the district plan are a critical part of delivering the outcome. So if it was to sit entirely outside the process, we come back to this concern we've got around the gap that would create within the district plan. Ms. Kane can speak to how the Apatihono Tatihono future work might look, but from my perspective, there would be a real drive from Hokonui for that to be a Gore-focused work stream, because otherwise Gore would have paralysis by just the amount of information that would be captured across the whole region. So to me, and it's just my own legal response, I feel for this policy to work and to be practical and to deliver an outcome, it would really need to be honed down to a Gore specific, Gore district specific outcome. But I would, having introduced that, I would kick that to Ms. Khan to give her view on as well once you get to her evidence, because she may have some thoughts on that.
Good, thank you.
I can move through the rest of the submissions relatively quickly. I mean, they're just introducing the relief from Ms. Beran, and that have been explored by the panel already this morning. So I don't need to read through those pages. One point I'd just like to emphasise that I've highlighted here is paragraph 82. Just to reiterate, really, that a lot of this relief really is driving at engagement and consultation with Hokonui, and that's a really important part of how the relevant triggers and catches that sit within the provisions that Courtney and Amy have been working on, how they're achieved is really a matter for that engagement and that consultation and communication, either from an applicant or from council staff. And I'd urge the panel to ask questions of the witnesses on this point, but it may be as simple as a quick phone call and that addresses the issue, or it may be that an application is much more complicated than that. But fundamentally, it's an engagement and consultation point. And I would just add as well that it's certainly not a right of veto type exercise. And the appellant courts, and I've put the case in my legal submissions, it's quoted a lot, is that mana whenua don't have a right of veto, and that's not what Hokonui are seeking here at all. And I think that's a really important contextual point to make. Moving through, triggered now section 32AA. This is around the 32 evaluation, for changes made, and the key one here is the variation. So I won't take Ms. Beran's thunder. I'll let her speak to that. And then, just for completeness, there was one additional. It's a field day zone provision that was missed from Ms. Beran's evidence. So I've just put that at Appendix A. It's just it's an equivalent relief to other policies that has just dropped off our list. Sorry, so I've put that there.
I guess just to flag the underlying words you've got there, wouldn't they sit better as a separate policy?
Within that same zone, I think it would achieve. It would achieve the same thing. I mean, the two policies would need to be interpreted in the round, but I'll let Ms. Beran think about it. But conceptually, I think that would achieve the same thing in terms of breaking the sentence up a little bit.
I guess from a legal perspective, going back to some of the questions that I was asking before in terms of matter of discretion, do you feel the way that the values are set out in section 2.3 provides sufficient certainty for applicants in preparing a consent?
Yes, I think they do. I would add though that they're just one part of that of the interpretation piece. It's likely that there would also be a conversation had to help guide and dig deeper into that. But given some matters of discretion or control are as broad as amenity effects, I think that this is actually giving a lot more direction than some. So yes, to answer that question.
Just having a chat here in terms of the convenient time for you to break for lunch, and it's not yet.
No, that's a good question.
And so we may get through 2 or 3 witnesses, but one of the longer ones, it would be better to actually stop before then.
No, thank you. That's a helpful signal. I just wonder if the panel were minded if I could call Terry and Joe perhaps before lunch, because they might be, and Terry's here, and then we could get to the nitty gritty after lunch.
By all means.
Cool. So, Terry, you just want to come up and maybe grab a seat.
Welcome, Terry. Thank you for your time.
And it's coming. Good.
So in the panel's hands, I've said to the witnesses that there's probably not a need for them to read out the evidence sort of verbatim, and that it's been pre-circulated. Some of the witnesses have some key points, but they're happy, and I think in Terry's case, happy to just move straight to questions as well, if the panel are happy with it.
The floor's yours, Terry. Thank you.
Cheers.
Moving straight to questions.
So there's an indication in the reports that the Runanga and Council are moving to another phase in terms of the Charter of Understanding. Can you just brief us in terms of the way you see that progressing and how it might tie in to some of the things we've been talking about today?
We are moving to a new face in a more collaborative manner, and just bringing our values and attributes also alongside the council. And I think it's prudent that we are involved in the plan, and I've instructed our legal sector and also our environmental sector to actually design the chapter that you're actually currently deciding upon, which is not in the documents, in the draft document of the Charter of Understanding. So it's another additional offering for consideration.
So if there's an intent to move forward to a variation or a plan change, will that be reflected in the formal documents between council? So in the new charter rather than, yeah.
Well, the charter that you currently got is a little bit outdated, and as legislation and all that actually changes, it's probably prudent that we actually discuss that and bring that in, because there's policy change and legislative change going on all the time at the moment, and we're just trying to actually stay in line with those changes, and there always will be variations to different documents that we actually develop together. And I'm not sure how we actually go about that, Keith, whether we initiate that straight away as the environment changes.
And that is what I'm leading towards. Our last hearings are in March of next year, and I anticipate June of next year before we actually release decisions.
Yeah.
Do you want to just turn it off while I'm talking, it's getting a bit of feedback? Cheers. So there, if the panel is dealing with submissions to the plan, there is nothing to stop from, subject to legal advice, the Runanga and Council together, outside of this process, actually agreeing to do things in the future and getting on with it. So in answer to your question, what is to stop you actually doing this extra work now? Otherwise, it's going to be another couple of years before you actually make progress. So you're not reliant on us actually putting a policy in the plan to say there's going to be a plan change. What you're reliant on is a negotiation with the council to agree on proceeding in that direction.
I think it's a wider negotiation than that, because it also gives the community the chance to actually approve or object. They're not going to get the same opportunity as they will if we just actually have an in-house discussion and we actually make that decision in-house, and then we actually start acting underneath that. You know, I mean, we're here for the long game, and we want to actually be as transparent as we can. And if there's opposition and there's criticisms, well, we'll actually work through that in a timely manner.
The way that the work is done, picking that you're looking at it as a collaborative process in terms of the assessments that are done and the reporting. Do you see either the council or yourselves taking a dominant role in actually preparing the documentation, or is that something you expect to be done jointly, and it comes back to the wording that's used in the policy?
I think it's jointly, if we are actually going to develop an effective and transparent process, amongst us.
I'd imagine the new MOU or agreement with council and what comes out of or precedes the variation will obviously have some synergy, won't they? They'll have to expect they would. But I take your point that any variation does allow for somebody outside that process to have some input. I personally don't see any disadvantage in the Runanga carrying on and developing the MOU, but that's outside the scope of this hearing panel, and the Runanga and Council will make your own decision. Any further questions for Mr. Nicholas?
Thank you, Mr. Chair. Terry, I'm just wondering if a new charter then would change anything that you could foresee in the district plan as it stands now, in the proposed district plan?
Well, I think the point is it wouldn't be written into the plan. I mean, that's my whole point. Is I think it's for obvious reasons. I think the English language is the most powerful language in the world, and you've got to have it actually clear, articulated, and actually provided. And I think that's the process that we want to go down. We want to be clear and concise of our conditions and our approaches and how we actually approach things.
Kia ora. I wanted to probably start at the end of your statement, at your paragraph 36, and wondering if this is really the key take-home message that you want to give us in terms of how to look at the way the plan works to support economic and environmental outcomes? Because you've got a very clear message in here that says that social and economic development must occur in ways which respect and restore the health of the whenua NY, protects remaining taonga species, wetland sites, etc. But you don't believe the economic and environmental prosperity need to be traded off. So when we're looking at how this plan is functioning and what the provisions are doing, is that your key message for us, and is there anything you want to elaborate on that?
There is quite a few key messages in there, and I don't want to elaborate them further, but I'll give you one example, is that wherever you look through the Ngāi Tahu Settlement Act and the claims and the evidence to the Privy Council, the House of Lords, the High Court and all the rest of it, we never ever sold our wetlands. That was one thing that we never did, because our wetlands actually provide us with with a food source, and is a very significant point. And a lot of people don't actually pick up in all that evidence through the tribunal when it finally got to the Privy Council. So there's a lot of values and underpinning that sit underneath this. In terms of the economic, the community's not healthy without economics. You know, it's whether we get the infrastructure right in this in the district to actually encourage economic. We will have a vibrant retail sector again. So, you know, I know we've got a lot of work to do together, and we're prepared to actually lend our collaboration in that, so we actually get this into a real vibrant town once more, because it is a significant town, and it's a crossroads of all ruralness.
Really interesting comment from you on wetlands. Thank you, I appreciate that. Interestingly too, the regional policy statement sets out the roles and responsibilities of both the regional council and territorials, and its provisions state that the regional council is responsible for land use management of wetlands. So it's actually outside of matters we can consider in the district plan.
I think it was just an example, you know.
I think, Terry, what you're actually saying is the environment and economics are linked together, isn't it, to make the town viable in the well-being.
If I address the social aspects, any development actually brings good and bad. You know, it's a huge social conscience that you've got to apply, whether it might be a big development, if you've got enough emergency facilities, is there enough schooling, is there enough housing, and importantly, is there enough policing? And you've got to measure all that together, and a project that I'm involved at the moment in the Southern Green Hydrogen, we're going through that again, and it's quite easy for me because I went through that with Solid Energy when Solid Energy wanted to actually populate their footprint here, is that they had to actually prove to us before we give them support that they ticked all 4 values, the Ngāi Tahu values. So we're pretty harsh in how we actually assess, and we'll be the first ones to say, if there's not enough emergency procedures here, we'll say it. And I know with one instance with that big development, Barry Taylor, who was the superintendent there at the time, he came and approached us and said, the community is going to be unsafe because we haven't got the policing staff to actually accommodate that. So straight away there, that was a discussion that I had with Don Elder and Solid Energy for CEO straight away, that we couldn't support that if we didn't actually address that. So it's those conscientious decisions that we've got to make from time to time.
You talk about the work of Kaupapa Taio and in your paragraph 28. So what do you see as the role of Kaupapa Taio working with the plan going forward?
I think this is that's a key fundamental because we have got a good Kaupapa Taio unit now, and we are just building upon that, and we've got succession coming through, and we're not going to actually die old in the job. We've got to actually look at succession, and that's what I'm heavily looking at the Runanga. We've got a young lady at the back there sitting in the court. She's coming through. Hopefully she will come through as a planner. And I've got another lady on maternity leave at the moment. Hopefully she'll come through as a planner. And we've got water science. I think we've got all the tools that we actually need to draw upon at our fingertips.
I wondered if you're looking at your paragraph 32 and you talk about Hokonui ethics, and I wondered when you say Hokonui ethics, should we be thinking about tikanga, kawa, te ao tahu, you know, what's kind of sitting in there?
It's interesting you bring that up. Before Cliff actually resigned, we had a discussion about discharge into the river, and we would like to actually have it out of the river, and we're coming close to the time when that consent is actually coming up. And as I said to the CEO and the Mayor when they come up to meet with us, we're going to have to find a solution and actually have a trigger in there. You know, we just can't let it continue. We've got to keep on testing our ability. Is there other alternatives? But we just can't let it sleep and just say that, no, we support it for a number of years. So myself and Cliff had that wider discussion, and that loomed on us, and we know that's a big issue here in this town.
So that's a segue to another question that I had following on there around examples from the last 10 years or so, to do with maybe clearing of indigenous vegetation or disturbance of wāhi tapu or impacts on landmarks and landscapes that's been harmful to Hokonui. So it would just be helpful for us if, because what we're trying to do through this plan is improve upon the past, can you think of examples? And I thought maybe the last 10 years was a good idea, because that's roughly the life of a plan. And, you know, yeah, so really thinking about these things that you're pointing to in your evidence around indigenous vegetation and wāhi tapu and landmarks and landscapes, just what your thoughts and examples that you can think of.
I can think about one probably about 15, 18 years ago where we missed the opportunity because it wasn't written into the cultural landscape, where Inky Tulloch was actually spraying the whenua, which was a huge biodiversity issue for us at the time, but it actually got through the legislation, and that was a lot of indigenous flora and fauna and all the rest of it, and I think it was just sprayed, and like the hillside looks nice now, and it's probably a 1080 debate that runs parallel, but that one there could have been managed a little bit more astutely. Our commitment to reimagining Mataura and the degradation of the Mataura River is actually, we're leading that. That's a 100, 150-year project. And we're starting from Fairlight all the way down to Mataura, right down to the where it meets the sea. And that's a big commitment that we've taken on, and we've actually attracted some quite key sponsors, corporate sponsors, and also Te Rangona Tahu are actually involved in it now. That's the commitment that we actually, we've taken on that challenge, and we're up for that challenge. And our September the 4th, we've got another expo on that Reimagine Mataura at the Ascot Park Hotel, if anybody wants to attend. I'm not sure if there's going to be an online link, but you can see the commitment that we're moving into.
So you're looking for the tools in this plan to support that, that vision?
Yeah, I mean, absolutely. You know, I mean, we can't do it alone. We've got to do it in collaboration with, you know, the farmers that actually border that river, the discharges that actually go in it from industry, and also, you know, the council need to actually be alongside us in that. And I think they are actually supporting that. You know, I mean, as I'm saying, a treaty partner's actually taken on that role. And we're not ratepayers subsidised to actually take on that role, but somebody's got to take on that role and clean that river up so people can actually swim. It's interesting with a lot of the information and the recordings of the older people that are still alive around today and the farmers that actually swum in that river, and they can't swim in there now.
Any further questions? Thank you very much for your input.
Oh, just thinking, well, we might go out on this one. It's just your paragraph 35. I wondered if what you're describing in there is manaakitanga.
Yeah, no, that's probably elaborated evidence to that 35, you know. We've got to have, you know, we've got to support industry, we've got to support economics. We've got to support the growth of a community in any way that we can.
Thanks for your input, Terry, and I wish you well in your ongoing deliberations with Council and MOU or whatever it's going to be. Thank you.
Just for our admin person, I'm just wondering whether those people online can hear clearly. Linda, have you been able to listen? Oh, it's Joe. Sorry. Right, you can hear. Okay, thank you. We had a problem with the first taping. And what we've got a speaker on there that actually picks up what people are saying and broadcasts it. I'm wondering whether we need a second one there that is turned off so that's got the speaker putting output.
It will be putting out what they say.
Okay.
Thanks, Terry. Thanks, panel. I'm conscious we've gone over 1 o'clock. Should we pause? Should we push on or pause?
I think for the other small one, I'm quite happy.
Could we call Joe and then have lunch? Great. So got Joe Brand up on the screen. Hi, Joe. Joe's prepared a relatively lengthy brief of evidence. Joe, just if there's anything you'd like to summarise or present, feel free. Otherwise, we can then move to questions from the panel.
I'd love to move straight to Pātai if that's possible.
That's fine.
I'm in person. I'm in Rapaki for a health week.
Joe, I found it a really interesting read, but I have no questions. Thank you. It was helpful.
Yes, similarly, I enjoyed the background, the Ngāi Tahu background. Thank you.
I don't have any questions either, but I did appreciate the history, Joe. It was really good to get the background of Ngāi Tahu. Thank you.
Kia ora. I do have some questions, but hopefully not too painful. So I'll just pull up your brief of evidence. Been a little bit slow. So at your paragraph 60, I'll just get down there. Where you're talking about mana. And I wondered...
Mana has the source at the point of creation, that one?
Yeah, yeah. And just kind of that whole passage there where you're talking about mana. Am I right that you're distinguishing in there between what I guess I'm going to describe it as mana atua and mana tangata? So what is enduring and can't be impacted and what is able to be impacted? Is that, like, you know, that there's... We've got... that we're trying to look after what can be impacted.
Sorry, I didn't quite hear what you just said in that last statement.
That we are trying to manage impacts on mana.
Aye, sorry, what is the question?
So am I right?
It's just very hard to hear you, it's a bit pitchy, sorry.
I'll try and, is that all right?
Yeah, it's a little better. It's probably more to do with my speakers, but okay.
Or my voice, I often have this trouble. So is there something to distinguish between mana atua and mana tangata? So thinking that...
Aye. So,
yeah.
Mana atua, you're talking the spiritual realm, whereas mana tangata, we're talking about the upholding the mana of other humans and each other.
And is it mana tangata that can be impacted and that's what we're trying to manage?
Aye. And I think, I can't remember which number it is in my evidence, but it does talk about we measure the health outcomes for tangata via Y as well. So yes, it all has an impact on each other, it all connects to each other.
I wondered if in paragraph 65 where you're talking about Hokanui supporting restoration of Māori, does the do you have some examples that you want to share?
In regards to Māori as a life force, or Māori in the context it's used in that sentence?
More about how Hokanui are supporting restoration of Māori.
Of the whenua, of the why, of the people?
Of all of the above. Just any examples, any examples you want to share.
Look, if I look at He Tangata, look, a good example is I'm sitting up at a very big hui at the moment with an iwi Māori Partnership Board to try and get it to pull the levers to ensure equity funding for our hospital. That's looking after the entire hapori. For Taio, we realised that whilst planting native trees is fabulous, there wasn't a supplier anywhere in the country that could really do it at volume. We've created that space. We can now and will do up to 1 million in our Te Tapua Tāne nursery. And I did hear you guys talking about Queenstown, just as an example, we're recloaking the Remarkables with native trees. So that'll take about that'll be 7 years of planting. And for the wide Reimagine Matilda project, which is a collective impact by multiple parties, not just mana whenua, to ensure that Māori is strong and prosperous and adding value to all the people in Mararoa.
Great examples, thank you. thinking about your discussion of utu, how might our decision on this plan assist in restoring balance?
That's a great pathway. This is my own opinion as opposed to speaking on behalf of all our members or my hapu. I think and it probably comes back to those conversations about the evolution of our agreement between Hokonui-Ruranga and GDC. Having strong, honest kōrero, trusting each other and being open to pushing past barriers to solve things together.
I'm so glad I asked. Thank you. In terms of your discussion of tino rangatiratanga, is this where Āpiti Hono Tātou Hono can help? And is this a way of expressing rangatiratanga?
Oh, you're on mute.
Araha mai, I didn't even realise I turned it back on. Can I have you repeat the pātai, please?
I'll try and simplify. Is Āpiti Hono Tātou Hono a way of expressing rangatiratanga?
I believe, in my personal opinion it is. I have been involved and I've brought whānau along and we didn't even realise how it was going to help us feel, being included in a decision making and also being informed to understand a process or something that's going on in the taio.
Kia ora. In terms of your discussion of mātauranga, I'm wondering how mātauranga is currently affected by degradation in the district and how are Hokonui supporting mātauranga into the future?
That's a rather large one with mātauranga.
It is a bit.
Look, there's multiple ways which we're trying to capture mātauranga, and look at a really simple example that happens in multiple ruranga, south and north, and that is the capture of kaumātua mātauranga through interviews, through pūrākau, through wānanga, and for example we have a panel workshop coming up in August with our expert that will pass that knowledge on, who's been taught for generation on generation on generation. But whilst we do the teach back on a wānanga situation, we're also recording it at the same time as we keep archives, so that mātauranga is there, and we have quite a build-up of archives, Hokonui-Ruranga, and also Ngāi Tahu. So there's a lot of mātauranga being captured. And I think there was a part 2 to your pathway then, Araha mai.
I think you've done my part 2, but I've got a part 3. And what role does the plan play in relation to supporting mātauranga into the future?
It recognises over 1,000 years of knowledge of the whenua, right down to the name of the valley being Maruawai, the valley of water, and knowing, that drainage has occurred. I mean, I am also a child of settlers, so I know where some of the drainage has occurred on, say, the Tūtaro farms. I believe that's how it feeds into it, but I'll be very clear, I'm not a taio expert, I'm in a whole other department.
Kia ora. We're almost done. In terms of wāhi tapu, which is a matter for us to work out through this process, how to help protect. Currently, how are wāhi tapu protected in the district?
Sorry, was that a question?
Oh yeah, how are wāhi tapu currently being protected in the district? Ah, well, there you go.
I mean, we've got some spaces. Are they protected? Are they upheld? Are they valued? Are they respected? I think that's a corridor for us all to have.
Where you're talking in I'm at paragraph 110 about cultural redress through the settlement process. So we've got in the plan, it's recognising the statutory acknowledgement for the river and freshwater mātaetai. Can you think of other elements of cultural redress that we need to be aware of that are relevant to the district?
For the plan, I don't feel qualified enough to give that information, if that makes sense.
Ka
I
pai.
mean, I could give you an example in my actual specialty of education, local curriculum.
Right. I reckon that'll do. Thank you so much. I appreciate your answers to my thorny little questions. Kia ora. We can all go to lunch, get some kai.
Thank you very much, Joe, for your input. And
Ka mihi, ka kite anō.
And we'll break for lunch, 2 o'clock, 45 minutes.
Power lunch, sounds good.